Good evening all, welcome back to my channel. It's quite some time since I posted any videos, but today I just thought I will give you the update on the Consumer Protection Act, the scenario where the Honorable Supreme Court has held a very important point, which I should say. Consumer Protection Act, any consumer can file a case before the Honorable Consumer Commission, provided the party comes under the definition of consumer. Now, this is very interesting because consumer, basically when we say consumer, we say it must be an individual or probably a group of individuals. This is what we feel when we say consumer. But commercial entities can also be taken as consumers. But there are certain criteria to that. Not every commercial entity can file a case under the Consumer Protection Act. It is very, very important, and this has been upheld by the Honorable Supreme Court. In the case Shriram Chits versus Raganand Associates, which was decided in this year 2024 May, it has been held by the Honorable Justices that anybody can be considered a consumer as per the Consumer Protection Act. But when we talk about the commercial purpose, we say sometimes what does the opposite party, the person who is against whom the case has been filed, what do they say? They say that the person who has filed the case, that is a complainant, is not a consumer, or sometimes they say that it is for commercial purpose. Even though the person is an individual, it is deemed, when the person's purpose of purchasing the particular item or good or whatever it is taken to be commercial purposes. So nowadays it has become quite common when we say that no, even though the person is an individual or a commercial entity or whatever it is, even though the person comes under the term consumer under the Consumer Protection Act, the person has availed the services or purchased the goods for the sake of commercial purposes. Therefore, this case cannot be maintained before the court. That is, the court cannot keep the case and decide the case. Okay, this is a common ground which is cropped up nowadays. Of course, in most of the cases it is true what the opposite party says, but in certain cases this is not true, and this has been put forth by the Honorable Supreme Court, as I already told you, in Shriram Chits versus Ragachand Associates, that commercial purposes, if the opposite party says that the consumer, that is a complainant, is involved in commercial purposes, it is the bounded duty, what we call as the duty of the opposite party to prove that the goods or the services were indeed for commercial purposes. We call it as burden of proof. So it is the burden of proving that the whatever are the services and goods availed by the complainant were for commercial purposes as defined under Commercial Protection Act should be proved by the opposite party. So this is the latest judgment in a consumer case by the Honorable Supreme Court. I just wanted to give you an update. Thank you.